Mr. Matonson?
Mr. Chairman,
Okay, I wanted to test if I'm audible. Can you share the agenda?
okay, you are audible. And Officer Minister Rana Baba Agrumela, another document, yes, seat allocation as an example. So I was trying to also send it to members, but I don't know if they will able to, but it will be shared. I can share it after the meeting, send it to members after the meeting.
Yeah, after the meeting, yeah. Because
Yeah,
now
send it now.
yeah.
They just send it now.
You can send after it's
So I
fine. You
was
can
saying
send after the meeting. Like
they will talk through it, yeah. Mm,
network here, man.
Sungula department Lanwan. Then here there will be questions and answers. And then I was thinking that here, because in our NCOP committee, then we do the draft program of the bill, and then we do a motion of desirability. Yeah, okay. I'm not sure if I think Adam might. This is came from last week, just before. I'm not sure if you will have something or whether you use that
And
document. Yeah,
just
this
remove
was
it. Item number 7.
yeah number 7. And he said
Yeah,
no, but
okay.
last time he said no, most of the stuff was covered by Elane, but he said no, there might be one or two issues that they might want to raise to the committee. That's why I left it like this. And then we deliberate.
Mr. Matonson.
Hello?
Okay, it's
Can
fine.
you hear
Let me
us?
just call you.
Oh, okay.
Recording in progress.
Good morning, Chair.
Morning, Mr. Matonsi.
Morning, Chairperson. Yes, it's exactly 10 o'clock. If we could start on time because of the sitting in the afternoon. Over to you, Chairperson.
Well, thanks very much, Mr. Matonsi. Morning, honorable members. Morning, the chairperson of the Select Committee, Security and Justice. Morning, the minister and your team, Parliamentary Legal Services, the state law advisors, the IEC team, and the Department of Communication, and all our colleagues who were presented in our oral submissions. As you have indicated, Mr. Matonsi, we had to adjourn to reschedule the meeting on Monday, given that the ministers requested that they're still consulting with their lawyers in terms of the responses, as he has indicated in our meeting, and we've granted that we need to reconsider the submissions and the request to give them time so that they have a proper consultation. Today, we'll then receive that response from the minister, and members will interact with that response. I'm aware that the IEC had also already indicated in our meeting that they still have to interact with the Parliamentary Legal Services or some of the issues. And I think when the time or members raise questions to that, they will able to respond, the Parliamentary Legal Services in particular. We'll not waste time, members, now that we're going to be sitting. As you know, that this week is a SONA debate, and at 2 o'clock, the sitting is going to reconvene. Mr. Matonsi and Mr. Dixon will deal with the item number 2 after the select chairperson has made a remark, and then we'll move straight to the minister. And then we'll then go to item number 4 and give all members to raise comments or questions. And we'll deal with item number 5. And then we'll deal with item number 6. Item number 7 and 8, it will depend on time allocated. We can, if we don't have more time, because the program that we've agreed with the 2 secretaries is that next week we ought to have more days to deliberate and deal with these other issues that are outstanding. But I think members will guide as the meeting progresses. Mr. Matonsi and Mr. Dixon can then deal with item number 2, apologies, and also indicate who is in the meeting.
Chairperson, morning, Chair. You indicated that before we do that, you wanted the chair of the select committee to say something before
Yes. Yeah, sorry. Sorry, select.
No, thanks, Chairperson. Maybe thanks for the welcome, but also let me just take the opportunity to greet the Minister, the National Commissioner, and all members and everybody else on this platform. I think, as you've indicated, given the time constraints we have, I suggest we move on with the agenda. Thank you, Chair.
Thank
you. Chairperson, from my side, from the committee side, I don't have any apology except that of Ms. Lehwase. She's here in the meeting. She said she was going to leave at 11 o'clock. The apology that I received is from the Deputy Minister. And then the members that we have here, Chair, from the Portfolio Committee is yourself, Ms. Mulekwa, Mr. Muhale, Mr. Pillay, Mr. Ross, Mr. Van der Merwe, Mr. Techane, Advocate Bongo, Ms. Modise, and Ms. Lehwase. I'm not sure if I've omitted someone, but also, Chairperson, in our meeting here, we have got Mr. Stephen Swart. He has indicated that no, he will attend most of our meetings, so he's here also in the meeting, Chairperson. Then I think maybe from the IEC and the department, they might have to introduce themselves, Chair. Over to Mr. Dixon.
Good morning, Chairperson, members, and Minister. We have an apology from Honourable Badenhorst and Honourable Dangle. And then in the meeting, we have our Chairperson, Honourable Sheikh, Honourable Maleka, Honourable Ndongeni, Honourable Bartlett, and Honourable Motsamai. Thank you, Chair.
Thank you very much. IEC, Commissioner Love.
Good morning, Chairperson. Good morning also to the members and the Minister and all present. I do have apologies from the Chairperson of the Commission. He is travelling for work purposes, but I am joined by the CEO and his team, and other members of the Commission will be joining us shortly. Thank you, Chairperson.
Thank you very much. Parliamentary Legal Services.
Good morning, Chairperson. It's Jelana Kali-Starkey here for Parliamentary Legal Services.
Thank you. State Law Advisors.
Good morning, Honourable Chair. Good morning to co-chairs, Honourable Sheikh, the Honourable members, the Honourable Minister, the commissioners from the IEC and all others present. Chairperson, the Oxler is represented this morning by Ms. Aisha Johar, Mr. Theo Hercules, and myself, Ms. Yara Governor. We will be noting the responses this morning in anticipation of drafting the A-list. Thank you, Theo. Thank you, Chairperson.
Thank you very much, Department of Communication. Department of Home Affairs.
Good morning, Chair. Good morning to all the colleagues on the platform in this meeting. Yes, in the Department of Home Affairs, as you heard, we won't be having the Deputy Minister today because he's trying to help the people in Danone who have had their IDs banned and they need to go and be helped. It's a special case. The Advocate Kumalo, the head of legal services, who's going to make the presentation, I've just spoken to him. Unfortunately, he said the system keeps on kicking him out, coming in and kicking out. And I said he must try something else, but he's going to make the presentation. From there, the DG is here. He may introduce whoever member of the department is on the platform. Thank you.
Thank you, DG.
Morning, Minister. Good morning, Chair, Honorable co-chairs. I think we also have from the department, Muzi Njoko, and also Thabo Mokhula, the acting spokesperson for the Minister, and also good morning to the IEC colleagues, the CEO, the DCO, and Commissioner Love. Thank you.
Thank you very much. All apologies are noted. We can now proceed, Advocate Kumalo, if you have now, Mr. Martins, Advocate joined.
Yes, Chairperson, he's in the meeting. I've made him a host to share his screen as well.
Thank you very much. You can proceed, and then Minister will also do addition. Then we'll then invite all members to comment on the raised questions on the all the presentation that has been made. Mr. Martins, in the meantime, will also interact with our colleague from Department of Communication who had presented their responses. What is their status to this meeting? Because members may want to raise some of the issues that they have presented. Advocate Kumalo, we are now inviting you to brief the committee. Mr. Matonzi?
Chairperson, it looks like he's not in the meeting. The system might have kicked him out already.
Okay. Do you have that report?
Chair, he will be joining shortly using the other device. If you can just give him a few seconds. It's just with me.
No, thanks, TJ.
Chair is actually with me. I hope Mr. Matons, if you're able to flight the report, you can do that on his behalf because we're using a different device. And then you take the report.
Okay.
Thank you, Chair. Good morning to all honorable members. You are here to run to the teacher's office. Yes, Chair. So this is the responses for the department to all the submissions that were made on the 6th of February. So on clause 3, there was a submission by my vote count where they said the definition of the donation and donation in kind should be amended to include the independent candidates and representatives. So as a department, we are saying we agree with this suggestion. Then the next submission was from CASAC. They were saying that the name of the fund already conveys the purpose, which is to enhance multi-party democracy. So the addition of independence is superfluous in this context. So the department agrees with that suggestion. And we are of the view that the names of the funds can remain as multi-party democracy fund and represented political party fund. The next submissions were from Dr. Albertus Skuman, Prof. Dirk Kutze, and the People's Legal Center, and Mr. Michael Atkins. They were saying that the new definition of independent candidates and independent representative poses a constitutional court judgment, I would say, issue in that it uses political party as an exclusionary criteria in violation of the principle of individual accountability. Now, as a department, we agree that the words "who is not a member of" can be removed from the clause, so that then the only thing that is left is "who is not listed," so who is not in the list of the candidates. So thank you, Chair. We can move to the next slide. Then on clause 9, which seeks to amend section 7 of the Political Party Funding Act, my vote count said we need to remove the inclusion of political party in the proposed amendment on section 7.3D and create a separate subsection or equivalent paragraph for litigation against the party. Section 7(2)(d) of the Political Party Funding Act only refers to legal cost relating to internal political party disputes and makes no mention of litigation against the party. Now, the department has had a closer look on this suggestion, and we are of the view that this clause or these words where we are trying to prohibit the use of the funds to fund litigation against a political party or independent representative or independent candidate, we are of the view that that could be deleted, because we might not have a fair justification as to why that prohibition. In other words, we do agree in the main that this may remain as it was in terms of just prohibiting the use of the fund money to fund litigation inter-party. So then clause 14, which seeks to amend section 10 of the PPFA, my vote count says clause 14 doesn't include independent candidates and representatives, and therefore excluding them from the explicit provision guarding against undue influence. Now, we are saying that the department agrees that the independent candidates and representative must be included. So, Chair, I must also just mention that we may not need to repeat these when it comes to the issues that were raised by the Parliamentary Legal Services, because to the extent that we have given responses to these issues, there will be similar issues that would have been raised thereunder. So we are saying that we agree that the independent candidates and representatives needs to be included. But we're also making a point, Chair and honorable members, that our initial policy position was to repeal Section 10 in its entirety, because in our view, it did not serve any purpose. But we were then, in a way, compelled to come up with a new clause 10 in order to take into account the recommendations that came from the Zondo Commission. And that is why then you see Section 10, this clause 14, the way that it is crafted. We still think that it will be difficult to enforce this particular provision, as a person can make a donation today not knowing whether the independent candidate will become a minister of a particular portfolio in future. And where a tender is advertised in that department, are we then saying that that donor is excluded from doing work with that particular department because they made initial donation today? So we are of the view that the portfolio committee and the joint committee may want to have a discussion on this clause and look at whether it is desirable at all to have it. Next slide, please. So the next one is clause 18, Chair, which seeks to amend section 12 of the Act. My vote counts says that the insertion of section 12A should therefore be amended to ensure that personal account of independent and be separate from the account used for donations to the independent. Furthermore, section 12A should be amended to include both independent candidates and independent representatives who as recipients of donations would both need to account for their income. So the department says we do agree that the independent candidates and independent representatives must be required to keep a separate account and to account for their income. In other words, they must be included in this provision as well. The next one, Chair, is clause 20, which seeks to amend Section 14 of the Act. My vote count says Clause 20 should be rewritten to explicitly include independent representatives along with independent candidates and political parties, and the department agrees with this suggestion. Next one, please. Now, Chair, we then come to Clause 26, Clause 29G, which is the determination of the upper limit, and Clause 29G, which is the determination of the disclosure limit, and Clause 26 deals with the powers of the president to make regulations. Now, my vote count, and also Dr. Skuman, Prof. Kose, People Legal Center, and Mr. Atkins, together with Inclusive Society and CASAC, we just take their comments all at once in this particular column. The comment says, generally, the bill does very little to remedy the fundamental concerns raised in my vote counts founding papers in relation to 1, the prescribed threshold for disclosure, 2, the prescribed amount of the upper limit on donations, and 3, the president's powers to stipulate those amounts. The president should not be allowed to have extensive or significant powers to change the core provisions of the Act in the absence of rigorous independent oversight. There is a conflict of interest in that the president, as a member of the political party, would be like an employee determining own salary, given a blank check. This provision is a regressive step for executive accountability and should be rejected. Parliament should retain its power to determine when the regulations should be amended and the different thresholds. Now, in terms of the responses, the department is of the view that in order to address these concerns that are raised regarding the powers of the president to make regulations in Clause 26A, we suggest that we must go back to the original formulation. In other words, we suggest that we remove the after consultation with the portfolio committee, and that the clause should then read, the president acting on a resolution of the National Assembly may, by proclamation in the Gazette, make regulations in respect of matters contemplated in Section 6, subsection 2, 7, subsection 2, paragraph E, 7, subsection 3, paragraph D, 8, subsection 2, 8, subsection 5, and 9, subsection 1, paragraph A. We believe that this formulation, together with the existing safeguards in the provision, which are the amount of money previously appropriated by Acts of Parliament for the Political Representative Fund within the previous financial 5 years, 2, the effects of inflation on the value of money over time, and 3, the costs associated with participating as a political party, independent representative, or independent candidate in the elections and the democratic process in South Africa. We are saying that in our view, then this should address all the concerns that were raised around the president's powers to make regulations. Next one, please. Now, as regards to Clause 29B, my vote count says the reconfiguration of the allocation formula is not a consequential amendment and therefore should not be included in the bill. The proposed formula will decrease funding of independent candidates, independent representatives, and smaller political parties. Now, in terms of our responses, we are saying that we are of the view that this amendment is consequential. The department is of a considered view that Section 236 of the Constitution should be a guiding principle when matters of political party funding are being deliberated upon. To this end, Section 236 of the Constitution stipulates as follows: To enhance multi-party democracy, national legislation must provide for the funding of political parties participating in the national and provincial legislatures on an equitable and proportional basis. Now, we are saying the rationale for Clause 29, therefore, emanates from Section 236 of the Constitution, hence the usage of the proportional and equitable principle. Firstly, the formula that is now the existing formula in the Act as it stands now, the 2/3, 1/3 split. So we are saying that the formula was suitable for political parties only. However, with the inclusion of the independents, the formula had to be amended, and that is why we are proposing that it should be amended. The rationale for the new formula is that with the addition of independents, the usage of 2/3 and 1/3 split will not amount to the allocation being proportional and equitable. We are of the view that the 90-10 split will ensure proportional and equitable allocation of funds. This split is in line with Section 236 of the Constitution. Next, please. Now, as we go on, then there were submissions that were made by the ANC, wherein the ANC proposes that every independent party who wins a seat in parliament gets a 0.25% of funds per seat they occupy, which is 1:400. The current formula of 6733 developed when few small parties were in parliament. The possibility now is that many more small parties and independents will participate. The ANC used the 10 parties and 28 independents of 400 MPs in their submission. If using the 6733 split, each independent MP gets 100 rands for every 17 rand for an MP of a party with 40% vote. A party with 25% gets 18 rands to 100 rands to an independent. A party with 25% gets 17 rand. I think that one is a repetition. A party with 12% gets 18 rand 50 cents for 100 rand to an independent. This is obviously neither proportional nor equitable. Then the ANC had provided a calculation in this regard. Now, the department is of the view, in terms of responding to this suggestion, is of the view that this suggestion is a better one in that it does not result in the negative unintended consequences of the 2/3, 1/3 split. And it takes care of the concerns raised regarding the 90-10 split. If the committee feels strongly that equitable needs specific increases in benefits for small parties and independents, we propose using the 90-10 as it gets close to proportionality with some additional support for small parties and independents. Independents and one party person in the example would double the allocation per MP of larger parties. So the Honorable Minister of Home Affairs would speak to this in a bit of detail when we talk of the example. That is the example that he would be speaking to. We reiterate again that the original formula was enacted under a different dispensation with political parties in mind, big or small. The current dispensation is totally different and deserves a new formula. Then we had COSATU, and COSATU was of the view that we need to amend clause 292A to replace the 90% of funding with 100%. And we needed to delete 292B in its entirety from the Act itself. The department is of the view that the proposed 100% is similar in effect to the 0.25 per seat and achieves the principle of proportionality. Then we had Mr. Atkins and Professor Kotse, whose comment was that the allocation of funds where proportionality component is decreased from, then we can move to the next so that I can finish. Is decreased from 67 to 90, sorry, is increased from 67 to 90%, while equity component is reduced from 33 to 10%, creates a grossly unfair change in the allocation of funds that favors the largest party and harms all the smallest parties. We can go back a bit so that I can take the department's views. As stated above, the department is of the view that I don't know what happened. The presentation has shifted.
Who's running the?
It's me, it's Eddie. I went back. You remember I was reading where the submitters raised, and then it has to go to the next page, and then I have to go back for him to start reading where it's stated above.
I think it will assist that you follow the request of Advocate Kumal. If he says go to the next page, yeah.
No, he did.
Okay. You can proceed, Advocate.
Chair, I will proceed from just what I have here, and I hope that will follow because right now I can't see anything on the screen.
Yeah, but the documents on the screen now.
Oh, it's flighted. Okay, let me just.
Mr. Matons, can you see on Honorable Shahida, can you see on your side?
Yes, it's clear.
Okay. I think all of us will.
Okay, Chair, I will just proceed because I think there is a problem with the gadget this side, but I think I will be able to work together with Mr. Matonzi because where we were now, we were just okay. Yes, I think I'm back on this side as well.
Thank you,
Chair, and sorry about that. So we just said that as regards to the responses to Prof. Kutsie and Mr. Atkins, we are saying, as stated above, the department is of a view that the 2/3 and 1/3 split will not amount to the allocation being proportional and equitable. So we can move to the next one. And then we are saying that the 67-33 distorts the proportionality and reduces all 5 of the biggest parties' share below what could be accepted as proportional. It pays out many times the amount per representative to the independent than to the large parties. The top 6 parties gets between 17% and 25%, and I think these will become clear as the minister presents of the allocation to independents per MP. It cannot be that being an independent comes with huge financial gain at the expense of a political party. Then CASAC had made the following. The amendment of 90-10 split is not consequential, is not a consequential one, and there is no need for it at this stage. It also disadvantages small parties. CASAC submit.
The first one and find the second one.
Advocate.
Thank you, Chair. Yes, Chair. Yes, I'm still here, Chair. I just wanted to.
Yeah, there was somebody who was interfering with your presentation.
Yes.
Can you request all of? Yeah, proceed. An apology for that.
Thank you, Chair. So CASAC submits that the existing division of funding allocation should be retained and that the proposed amendment should be rejected. We obviously disagree with this. We are still of the view that this provision is consequential, it is not substantive, and we then refer to our comments above. Next one, please, Mr. Matonzi. So now we come to clause 38 to 40, and this now speaks to the Electronic Communications Act, and my vote count was saying that all these sections that are listed here do not include the term independent representative. Obviously, then the department also looked at this, and we agreed that the independent representative should be included. Then, Chair, there were issues that were not covered in the bill, and that the first issue related to Section 27CB of the Electoral Act. And my vote count was saying that they recommend that Section 272CB must be amended prior to the 2024 elections in order to ensure that there is parity amongst the different categories, so that elections that are constitutionally sound are held. Now, the department, Parliament, and IC have already filed explanatory affidavits to assist the Constitutional Court in arriving at a fair decision. We therefore advise the committee to process the bill and allow the court process to take its course. And on the second issue that was not covered in the bill is the issue of Section 23 of the Political Party Funding Act. My vote counts is saying that Section 23 of the PPFA prohibits Parliament or any provincial legislature from funding a representative political party other than through the stipulated legislation. Section 232 stipulates the responsibilities of the accounting officer to report annually. Neither of these makes mention of independent representatives. So the department says we agree that should this be amended, then the representatives, independent must be included as well. Next one, please, Mr. Matonzi. Now, Honorable Chair, we now come to the issues that were raised by the Parliamentary Legal Services, because most of them, they needed the department to respond, especially to indicate policy intentions behind certain clauses. Well, I think we have already covered the issue of the definition of donation in kind and donation. And we said that we agree with Parliamentary Legal Services that this must then include independent representatives and independent candidates. So we agree with that. The next issue that was raised was the issue around Section 10. Now, in this regard, Parliamentary Legal Services was saying that they do agree with the submissions. This provision provides that no person may make a donation to a political party or a member of a political party with the expectation that the party or a member concerned will influence the awarding of a tender. It does not include the independent candidates or independent, I would say, representatives or independent candidates with a seat in the National Assembly or provincial legislature, that is independent representatives. There is no legal justification for this exclusion unless the department has a policy intention not to include the independent candidates in this provision. If so, must provide reasons for the exclusion. Furthermore, the DHA should provide a policy understanding as to why the section was amended, as currently Section 10 prevents any person or entity from a delivery of a donation to a member of a political party other than for political party purposes. We can go down so that I can finalize the submission by the response by Parliamentary Legal Services. Yes, as it includes the proviso in expectation that it will influence the award of a tender or license or approval. Then we can go back, Mr. Matonzi. Yes, so the department agrees with the Parliamentary Legal Services that the amendment should include independent representatives. And we are saying that with caution that we have already submitted above to this committee that we think that the issue of Section 10, which we have indicated that it had been influenced by the recommendations of the Zondo Commission, should be thoroughly discussed by the Portfolio Committee and Parliament. So should this amendment stand, so we do agree with the legal services of Parliament. Thank you. We can go to the next one. Then the next one was on Section 14. Here they said that only independent candidates and political parties are included in the section. Section 14 relates to the Commission's duty to monitor compliance by political parties with the Act. The amendment, therefore, now includes all independent candidates, regardless of whether they receive a seat in the National Assembly or provincial legislature. Therefore, there is no need to include independent representatives. However, this section could be interpreted widely to mean that once an independent candidate gains a seat, the provision does not apply. And so we took this into account, and our policy intention was for the Commission to monitor compliance of political parties, independent candidates, and independent representatives. For completeness, we propose that the independent representatives be expressly included. Then the next one was on Section 19, and the Parliamentary Legal Services were agreeing with the submissions. Section 19 stipulates offenses and penalties. The amendment then introduces a subsection 3, which provides that any person who makes a donation to influence a tender or license commits an offense and stipulates a fine. It then introduces subsection 4, which creates an offense for any person who makes a donation to a member of a political party as opposed to the political party itself, in order to circumvent the provisions of Chapter 3. That is the direct donations to political parties, independent representatives, independent candidates. They are saying that there is no need, there is no legal justification to exclude independent representatives or independent candidates in subsection 4, and as reference to Chapter 3 includes them. DHA must provide policy as to why they have been excluded, unless this was an omission. So we are saying the department agrees that independent representatives and independent candidates must be included in subsection 4. Next one, please, Mr. Matonzi. Then this one, Chair, is the one that relates to the issue of the formula or the split. Legal Services is saying this is a substantive amendment, as this amendment amends the formula used to allocate funds and is not a simple consequential amendment as a result of the amendment to the Electoral Amendment Act. The regulations to the now repealed Public Funding Represented Political Parties Act provided that the allocations would be calculated through a 90 proportional and a 10% equitable calculation. The previous Parliament had its reasons for changing this provision to 2/3 and 1/3 split. These reasons were steeped in policy. The amendment bill now reverts to the original formula, and this is based on a policy derived from the executive. It is the prerogative of the executive to develop policy, and it is up to Parliament to then interrogate the policy when it is presented in legislation. Therefore, the justification behind this amendment is best left to the DHA to provide an understanding and reasoning behind the amendment. However, Legal Services would like to caution the committee that this is a substantive change to the Political Party Funding Act. Independent representatives will always have an unequal footing due to the political nature of the institution, independent representatives only having one seat and political parties having more than one. But should the change in formula result in an unfair discrimination, independent representatives of smaller parties, the committee must be mindful of the principle set out in Huxon versus Lane. Does the provision differentiate between people or categories of people? If so, if we can move to the next one. If so, differentiation bear a rational connection to the legitimate government purpose. The rationale behind the legitimate government purpose will be left to the DHA to advise on. We can go back, Mr. Matonzi. So we are saying that we have responded fully to this matter above. And so we can move to the next one. Yes, thank you. Then the next one was Section 7 of the Political Party Funding Act, which provides the purpose for which money from the funds may be used. The amendment to Section 7 provides for a new subsection 3 that stipulates that money paid by the Commission to each independent representative may not be used by an independent representative for the purpose of paying remuneration to a person who is appointed by the state to finance or contribute any event or occasion in contravention of any codes of ethics. 3, directly establish any business. D, for the purpose of covering any cost relating to litigation against a political party or independent representative. So, Chair, I will just be quick on this one because then the legal service said we must provide a policy position and the intention against this. So we are saying that it is the department's policy intention behind this new insertion to prohibit political parties, independent candidates, and independent representatives from using monies received from the fund for personal use. We agree that and we have covered this above. So where we agree that the words or to cover any cost related to any litigation against such political party, independent candidates, representatives, requires a discussion by the portfolio committee, possibly redraft or delete. In fact, our solid recommendation was that this should be deleted from the clause because, as we have said above, that it would be difficult to justify why we are prohibiting political parties from using the funds when they are being litigated upon. Chair, I think that should take us to the last, the last part one slide. So then there was the issue of clause 26. Chair, I will not read it now just for being mindful of time because what is being raised here we have addressed above in terms of the issue of the presidential powers to make regulations. We have actually made a suggestion that we go back to the original formulation, that it will be acting under the resolution of the National Assembly. So we can move to the next one. Then the next one, which is the last one, is the Electoral Commission Act. Then I think this one we have already addressed, Chair, and we said we agree that the independent representatives must then be included in these sections as well. Then I think that takes care of it. That takes care of it. And then on technical issues, Chair and honorable members, we are saying that the words parliamentary resolution in clause 29G, 29H, be replaced by the resolution of the National Assembly, because as we were discussing as a department, an issue was raised when we say parliamentary resolution, do we mean both houses which must make this resolution? So we thought then, for clarity and making sure that there is no confusion, it must be stated that the resolution of the National Assembly. And B, we are saying that the words not exceeding 200,000 in clause 24B must be deleted. We are of the view that there must be flexibility in determining these amounts. We are saying that it is not desirable to include the amounts in the Act, because every time maybe Parliament is of the view that this should be changed to 300,000, then we must have a bill that then amends such, so that this could be provided for maybe, in some regulations. Chair, we thank you, and that is the end of the responses by the department. Chair, as you have indicated, that then the Honourable Minister will then give more clarity on some of these responses, Chair. I thank you.
Thanks very much, Advocate Mahlangu, for the detailed response. I will invite the Minister to deal with the other item that he was requested to deal with. Minister?
Yeah, Chairperson, is Advocate Kumalo, not Mahlangu, just for correction.
Sorry. Apologies.
Yes. No, thank you. Understandable. No, honorable members, I thought I would take up a few issues, which in the presentation of Advocate Kumalo, well, he tried to explain them, but I want to make further explanations. Firstly, can I get slide number 2? Slide 2, where he talks about section 10 of the PFMA on clause 14.
Yeah, okay, sure.
Yes. That what is 13. Slide 2 or page 2. Oh. The second slide or second page, yes. Yes, thank you very much. Now, on clause 14 of this bill, that is the subject of this discussion. We have substituted clause 10 of the Political Party Funding Act by that clause 14, which is now a subject for discussion. I want to read to you the Political Party Funding Act as it was enacted in 2018. It says, prohibition on donations to members of political parties. Subsection 1, no person or entity may deliver a donation to a member of a political party other than for party political purposes. Subsection 2 says, a member of a political party may only receive a donation contemplated in subsection 1 on behalf of the party. And subsection 3 says, no person may circumvent subsection 1 or 2 or any other provisions of this chapter. Now, as you are aware, Chairperson, this Electoral Amendment Act, which has been passed, and subsequently this bill, were drafted by Senior Counsel Advocate Steve Bartlander. Now, during the drafting, he asked me a question. He phoned me and asked me a question. He said, can you explain to me what was the legitimate purpose of Parliament when they enacted this section 10? Because he does not understand it. He does not understand how it's going to work. He doesn't understand what purpose does it serve, except criminalizing anybody who is a member of Parliament. I could not get answers because in our discussion, we discussed things like, when you say no person or entity may deliver a donation to a member of a political party, what type of donation are you talking about? Because members of political parties do receive donations, indeed. I'm sure all of us here have received some form of gifts or donations in whatever way which in terms of the law, you are forced to declare. And many of us have declared. If you don't declare, you actually even get punished by the Parliament Ethics Committee. But none of us, after declaring, have taken that money to the political party, as it's been stipulated here. So the question is, how do we police this, and what purpose is it serving? Secondly, people do receive donations in kind when they've got bereavement, when they've got parties, when they've got whatever social events, yet they are members of political parties. Is that included here or not? So after a lot of deliberations, honorable members, we agreed that we don't think this section 10 of the PFMA serves any legitimate purpose. So we must exclude it. We must delete it altogether. It must not exist. Now, after having taken that decision, another issue came to the fore, the issue of the Zondo Commission, where Zondo Commission said a clause must be found somewhere in legislation which criminalizes an entity which donates money to a political party with a view to getting favors in the form of tenders or whatever. That's what Zondo said. And then it was then believed that it needs to be included in this legislation because the president came to Parliament and allocated and showed the responsibility of each entity in terms of the State Capture Commission, each entity, what the recommendations are saying. And so this recommendation was given specifically to Home Affairs. It was then thought that while we repeal Section 10 altogether, let's have a new Section 10 as this Zondo Commission recommendation. We could have put this recommendation anywhere, but we said now that there is a space in Section 10, that the old Section 10 was removed, let's put that this one. And it is this one on which parties have commented, including Parliamentary Legal Services, about exactly what this means. Now, Chair, I want guidance from the committee because we had questions about this issue. Firstly, what jurisdiction anywhere in the world is following something like that, where people who happen to have joined political parties can no longer receive gifts, even when in South Africa itself we know they are receiving them, but it's forbidden by legislation. We did not find any jurisdiction where such a thing is happening. The second substantive issue on which I want guidance from honorable members is if we put that recommendation as the State Capture Commission has mandated, what does it mean? And here are the pertinent questions. Does it mean that once an entity, legal entity or a persona entity, donates to a particular individual or political party, they are then excluded from future work? I want to give an example. Honorable Lizelle van der Merwe, forgive me. I'm going to give an example of your party. I just really chose it at random. At the moment, I'm choosing it because at the moment, it is not in government anyway, it's not in power. If I'm talking at national or provincial level, if somebody decides now that is donating money, and let me be specific, if somebody who owns a construction company decides that is going to donate money to the IFP simply because he loves its policies and etc., and clearly there's no expectation because IFP cannot issue any contract since it's not in power, and the person donates and has got no problem in being disclosed publicly in terms of the disclosures that that person has donated to the IFP. And then the IFP comes into power. Obviously, they are going to issue contracts for building schools, roads, bridges, etc. Now, this person is in the construction industry. and some 5 years ago or so, he donated to the IFP. Is that person excluded? Or is he going to be looked upon as somebody who bought his space, anticipating that the IFP may come into power? I want clarity from members of committee on practical things like that. Lastly, Chairperson, without wasting your time, the reason that I want your guidance is because this thing has already happened in the past. And unfortunately, when it happened, it even involved Madiba. And I need to explain what I'm talking about without wasting your time. I was the first MEC for education in Limpopo. And Madiba was worried about the facilities of education in both Eastern Cape and Limpopo. He then approached a company called Reach and Teach, which is an NGO that no longer exists now. Reach and Teach was established by a company called IBM, which you all know is dealing with computers. But they established Reach and Teach as a social responsibility partner, whereby they must help schools and all that, capacity building, IT, technology, and all that. So Madiba approached them and said they must donate 3,000 computers to Limpopo Department of Education and Eastern Cape. And they agreed. And then said, as you know, IBM is a company which emerged from the US. They then said, for Reach and Teach, when IBM established Reach and Teach, it depends on philanthropies from the US. It will be better if somebody representing these poor provinces that Madiba has identified goes to the US to talk to philanthropists, tell them about the status of education, what Bantu education has done, etc., so that they open their pockets. I was selected for that. Reach and Teach bought me a ticket to go to the US and address several meetings. And of course, we came back expecting donations. One day when we met Reach and Teach implementing this project, they then asked me a question. They said, MEC, while we are donating computers to you, our mother company is IBM. Is it excluded from tenders because of this donation? Is it, in other words, while we are donating computers, if the government then have money to buy computers, no longer waiting for donation, but buying actively, are we now excluded as IBM because we donated at the request of Madiba? Then I said, why are you asking that question? They said, no, your department has just bought computers for 15 million. Honorable members, remember, 15 million in 1996. They said they made it a blue tender from which we excluded. I said, there's no such a thing because I never knew about it. They said, no, it's there. I asked my officials who confirmed, indeed, we bought those computers. And honorable members, I found that we bought even to schools which were still attending under trees, for which we're still putting up buildings. And I asked them, who instructed you? They said, no, MEC, you once addressed a mass meeting where you spoke about acquiring computers in order to improve education, and we took it from there. I said, but that was not an instruction. It was a speech. But anyway, when I checked, I smelled a rat. We took this matter to court. And in court, the gentleman said, no. This MEC is worried of his friends who sent him to America and even bought him a ticket, that his friends never participated in this tender, and he's angry about it. Honorable members, that day, I was so depressed, even Madiba phoned me to console me because his name was appearing there in court about how he came up with this donation. But the only case on technicalities, of course, and the person who issued that contract, his delegation ended at 100,000, but he issued a contract of 15 million and excluding all others, including this IBM. So they asked me this question, are we now excluded so that in future when we donate, we must think very carefully? Because our donating to Madiba does not mean that we are no longer in the business of selling computers. So I gave an example where I quoted the IFP. I'm giving this example. What do we mean, honorable members, in this clause that a person must donate not expecting anything? Perhaps the last thing, I'm just opening up all possibilities. The last and third thing I want to mention, when companies sponsor, don't they have expectation? We had recently Carling Black Label sponsoring a match. It matches in the PSL. Are they doing that for free? What is the PSL going to pay them? Of course, zero. But they are not expecting that liquor must be bought. And it gets bought. Liquor, it gets bought in huge numbers because of sponsorship, as you know. You are aware that cigarette sponsorships were stopped by Honorable Nkosana Dlamini Zuma for this purpose. We've been struggling to stop liquor sponsorship because they are destroying our people. But are those sponsorship innocent? Are they not expecting something in return? These are the three issues I want to put in front of the committee. Please help us in terms of this. But we believe the original Section 10 of the PFMA, you agree with us, it gets deleted because it serves no purpose as shown by Senior Counsel Steve Bartlander. Now, the question on the table is, do we replace it with on this Zondo Commission? What weighting do we put in view of the examples I've given? How do you guide me in those examples? Chairperson, that is the first issue. The second one, can you take me to slide 4? Yes. Yeah, this section 20, 29. Your slides are jumping around. Yes. Can you just go to slide 4 and stop there? Let them not jump around, please. Yes. Thank you. Oh, gosh. No. I'm sure you are placing many times. I want slide 4 and stop there, please. Yes. Honorable members, the argument here is that these issues of formulae and especially the issue of a new formula is that it is not consequential. We argue very strongly, Chair, that the formula of how to allocate money is very consequential because it was determined at the time when we have got only political parties and no independence. The introduction of independence will definitely temper with Section 236 of the Constitution. And honorable members will remember that this matter was raised in court during the recent litigation of when we were taken to court, that the political amendment, the Electoral Amendment Act is unconstitutional in as far as independence are concerned. That the choice was made. Remember, there were two choices from the committee chaired by Vali Musa. They said the second choice we made is unconstitutional. And we went to court to prove how we made that choice. And we quoted Section 46D and for Section 105D, which says whatever Parliament does in terms of allocation of seats, etc., it must end up in proportional representation. If you read the judgment, it says 100% proportional representation is not possible at all, but something close to it will do, something closer to proportional. Now, in this case, honorable members, where does this issue of giving money to political parties come from? It stems from Section 236 of the Constitution, which says to enhance multi-party democracy. In other words, the Constitution knew that multi-party democracy needs to be funded. Nobody runs a multi-party democracy without any funds. So it says to enhance multi-party democracy, national legislation must provide for the funding of political parties participating in national and provincial legislature on an equitable and proportional basis. If I take you, honorable members, to the early days of making this amendment, I'm one of the people who publicly said the amendment from the Constitutional Court to include independence is impossible without amending the Constitution. I said so in a meeting of the Portfolio Committee, and I hope it is minuted somewhere. That is impossible. We need to amend the Constitution first before we can go to the Constitutional Court. All the legal eagles told me that there is nothing like that, that when they say multi-party democracy, they don't necessarily mean political parties or what. They mean parties around, parties that are enhanced, are participating in this democracy. Just like, as you know, internationally, when there are negotiations, they say the parties, conference of the parties. They are just talking about those individuals or entities that are sitting around the table. That was the explanation given to me. Now, back to 236. 236 means multi-party democracy has to be funded. But the question doesn't stop there. It says when you fund it, it must be both equitable and also proportional basis. And the formula are actually designed to meet that equitable and proportional. Now, equitable and proportional, at the time when there were only political parties, will be completely different from equitable and proportional when you include independence. Now, in this regard, we looked at the presentation from ANC because it was even giving examples. Can you go to it? The presentation from ANC Advocate Kumalo read. We looked at it because ANC is making particular arguments, even COSATU. Can you go forward to it?
Minister, you want me to go to the ANC submission?
No, here on this slide, Advocate Kumalo read something from ANC. Let me try to guide you. I think it's in. Yeah, it's on slide 6. Yes. We looked at what ANC is saying there, and we wanted to know whether the ANC is telling the truth or whether this rationale is they are saying. We took hint from the mathematical presentation put by Mr. Atkins, which were also quoted in court, and we said, let's test this ANC proposal. We approached Mr. Norman du Plessis, who for a long time, as you know, in the past, was a deputy, a CEO of the Electoral Commission. We were told that one of his specialties was graphs, numbers, and figures. We asked him to produce graphs, numbers and figures in order to prove these various splits, which one is more proportional. Because we argue right from the beginning, even before Mr. du Plessis produced any figures, that colleagues, the split of 67-33 was suitable when there were no independence. Once you bring independence, it is neither proportional nor equitable. You are actually destroying two areas of the Constitution, that of proportionality and equitable, both of them. When we looked at the one that ANC is proposing of 0.25% per seat, it meets proportionality 100% this time around. But the issue of equity is not catered for. But when we look at 90-10, we found that it approximates both proportionality and equitably, in line with what the Constitutional Court has said, that something that approximates proportionality will be acceptable. So we asked Mr. du Plessis to produce the figures for us. I know that you not got them before, but I want to present them to you officially. Muzi, can you help? I've sent you a spreadsheet that shows those calculations. No. Are you sure it is this one? Because there is one which is even more clear. Muzi, there's a spreadsheet that is even more clear with many more columns than what you have put on the screen. I think I sent you 2 spreadsheets. Where is the other one?
Minister, this is the second spreadsheet that you sent me.
Okay.
Where's
okay.
this one?
No, it's okay. Let me try on this one. Okay. Yes, the figures here are trying to show various permutations. If you have got a political party A, which has got 160 seats, that is 40% of parliament of 400 seats. If you give 0.25% per seat, that means you have taken you have divided 1 by 400 seats. It gives you 0.25%. In terms of proportionality, it is 40. Yeah, man, this one doesn't really show things the way they should be. Can you put the other one? The first one I gave you. Yes. If you look at this spreadsheet, can you go a little bit above, please? Can you go up? Can you put it up again? Yeah, okay, fine. If you look at this spreadsheet, it shows the number of seats, the percentage of seats. If you give 25%, if you allocate via 33, firstly, it shows 0.67%. That is the 67. How much a party gets and how much an independent gets proportionally. And if you give equitable, and when you add them all together, because eventually the money is together, it shows there, as I'm giving an example of Party A, with 160 seats, is 40% of parliament. It gets exactly 40% of the allocation. But if you distribute it via 6733, it gets only 26.8% of the allocation. And then their share of 33 will be 0.87. That is for all the parties. But when you get them together, you'll find the column there which shows 27.67. For the second party, 17.62. It was even done by calculating funding per MP. If you do funding per MP, a party with 160 members will get 17 cents for every rand. The second party with 100 members will get 18 cents. The third party with 48 members will get 19 cents, etc. And you go down until, can you go down until you reach the independence? When you come to the smaller parties and independents, it goes far above a fraction. It shows 1.04, 1.04. And it shows that per MP, an independent gets 4 times what an MP of a political party is going to get. If you do 90-10, the independents still get twice what the political party gets, but we believe that is understandable. Now, the last column, can you go up to show what this last column is all about, Muzi? Can you go up? No, down then. Down. No. Okay. Yeah. Again, up. Push again in the same direction, because it looks my up and down are different from yours. Push again, or I'm the one who's confusing. Again, right up to the top. Yes. If what we are calculating there is advantage over larger parties, that means what is the advantage of an independent over a larger party? On the first party, the independent has got 100% advantage. On the second biggest party has got 101%. On the third biggest party has got 107%. On the fourth biggest party has got 114%, etc. And when you move down, it even reaches up to 600%. As you go down, you find 599 there. Whereas at the yes, these are the advantages that an independent will get over the political parties. If you move over to the last column, can you go up? I want to see the heading on the last column. Yes. If you use 90-10, you can see that there is a huge difference there. It's only 36%, not 100, 2250, 107, etc. So we want to argue that all in all, what Mr. Du Plessis was proving here, and we believe if there's any other formula that is better than this one, we invite members to bring it or bring their experts. But what is proving here is that the formula of 6733 is grossly distorting proportionality and not even equity. So both of them in the Constitution are not satisfied. The formula of 0.25% of the funds be given to every seat is 100% proportional, but it does not deal with equity. The only one that approximates both equity and proportionality is 90-10. So we were actually advocating for 90-10 on those grounds, honorable members. Next, can you remove this? I want to continue. So we believe what we are doing is definitely consequential. We are not just making a change here. Then the issue of limits, it is still on the same slide. Advocate has already said we have considered that perhaps we must not change the previous Political Party Funding Act. The previous Political Party Funding Act has given this power to change regulations to the president, only that the regulations were never changed. But it says the president must only do so with a resolution from the National Assembly. That means the National Assembly sits and say we think things must change. Why do we then, honorable members, propose this? We even said we are adding something new that is not in the Political Party Funding Act, something new. That in the parliament reaching a resolution, both parliament and president must work within 3 parameters, and I'm going to explain them. It's not just a blanket check. They look at 3 things. The first one is, how much did the fiscus give? And the rationale behind this is that when the Political Party Funding Act was enacted, it was not envisaged that political parties will run their parties without money. No, nobody in the world does that. To run a political party and run for election, it needs money. What was envisaged was that we don't want influence from outside factors. So because in the Funding Act, there are 2 sources of money. One, fiscus, which comes from the taxpayer. And so the influence over parties by the taxpayer is the same. It can't be any different. The second is private. And to curtail private funding, limits were put. Two limits were put. One, the limit at which you have got to be declared publicly. And two, the upper limit to which you can donate, which is 15 million. And the limit for declaring is for being declared publicly is 100,000. Now, those were put in to curtail private funding with the belief that the money must come from the fiscus. That was the objective, not that political parties must just go and run and see to the finish, because what we'll do then is to go and find some other innovative method which might not be legal and ethical. The fiscus must fund. Now, when the act was passed, I was arriving in Home Affairs. I went to Treasury to ask them about this issue, that now that the money to IEC comes from Home Affairs and you have curtailed private funding, what is the fiscus giving? And Treasury said, as you can see, the economy is staggering, we can no longer do that. I then said, but then what do political parties do? You curtail their private funding, we all agreed, everybody is happy in terms of ethics, but how do they run their parties if Treasury is not coming to the party? Then they started throwing some bids here and there, bids here and there. Like now, I'm informing you, we've just received a letter that in order to prepare for elections, we are going to get 200 million, which all political parties must share among themselves. You all know that is not anywhere near being adequate. So for that reason, we believe the issue of how much the fiscus must give must correspond to how much do we open up for private funding in terms of the restrictions. If the fiscus gives 100% of what is needed, then we don't have to determine any upper limits and lower limits. The fiscus will have given. But unfortunately, as I'm sitting here, it is not giving anything nearer enough. So that is the first thing we think Parliament must consider. The second thing is to look at inflation. Inflation changes with times. What is the rate of inflation at that time? Can Parliament consider that together with the President? The last important thing, how much do political parties spend on average to run a political party in order to enhance multi-party democracy? And how much do they spend during the time of any election? Local government, then provincial and national. How much do parties spend? Can the parties present to Parliament and say, on average, we spend this much, and then we average them and see exactly how far is it? Is the Treasury helpful? Because if Treasury says we are giving you 200 million, and we found that all political parties together, they spent a billion rands to run their election altogether, and Treasury say only 200 million is available, how much are we helping Section 26 of Constitution of enhancing multi-party democracy? So those are the proposals we made, and we believe, Chairperson, if Parliament does its work on these three parameters, what the fiscus is giving, inflation, and how much parties are spending, they ought to be able to come nearer a good figure of how much must we curtail private funding. And I'm repeating, if Treasury gives 100%, let's forget about private funding, let's forget about limits. But the reality is that it is not like that. Then the last issue, Chair, and I think that is slide 11. Yes, slide 11, honorable members, is this issue from the responses, even from parliamentary legal services, that we must amend Section 27 2 CB. We must amend it even to make it to make independence and political parties equitable in terms of signatures, obviously. You will be aware that this matter is in court, honorable members, and for us it's difficult to see how do we preempt a court outcome. Both Parliament and the IEC and Home Affairs have decided that they are not opposing this matter, but they are filing explanatory affidavits because, Chair, case law, which was made several times, dictates that if you have passed an act of Parliament and is being challenged, you can't just say, I abide. The courts reject that. You must give an explanatory affidavit to guide the court, even if you are not opposing, to guide the court how to arrive at an equitable or a justifiable solution. That we have done. I think Parliament has sent in their affidavits. The IEC have done so. Certainly, I know Home Affairs will have sent that explanatory affidavit. We are waiting to see what the Constitutional Court says. Now, for us to rush here and preempt and start amending something, what will we be doing that for? Are we anticipating that the Constitutional Court will rule in one particular way? And we don't think so. And so we believe, let's leave the Constitutional Court do their work. We cannot amend this now, Chairperson. That's basically what we are asking of the committee. And thank you very much, Chair. Thank you.
Thank you very much, Minister and your team. And thanks all that we have now responded to the issues. The IEC have give account of the responses, Department of Communication, and the thrust of all the responses talk to the issues raised by our colleagues during the oral submissions. I'm going to now, Mr. Matonsi and Mr. Dixon, invite hands. You'll assist me, hands that are raised, but I'll start with the Honorable Shaida to give a comment. Then after that, we'll go to the MOD. Then we'll given time, invite responses from IEC Minister and the Department of Communication. Then we'll take deliberations on Monday so that we allow honorable members to proceed to the House on their travel arrangements. Honorable Shaida Sheikh, then Mr. Matonsi, Mr. Dixon, you will alert me on the hands because in the last meeting, other members could not able to raise hands, but they wanted to contribute so that we don't those that they can't able to raise hands, you must indicate so that we're noting you on the line of comments. Honorable Shaida Sheikh.
Thank you very much, Chairperson, for allowing me to comment at this point. I think we should also, I would also want to thank and note all responses from the Department of Home Affairs, the IEC, the Department of Communications and Digital Technologies, as well as the Parliamentary Legal Services, but also to thank the department as well in terms of taking the process a lot further and responding to the comments that the Parliamentary Legal Services has raised, especially from a policy and technical perspective. Chair, I don't have anything to say now because I don't want to engage into the discussion or the deliberation yet, but just to thank them and to note all the presentation. But broadly to say, Chair, that there's a lot of technical corrections that are being made to the bill, and that we should note this. Obviously, there are other issues that have been flagged for further discussion and deliberation, and perhaps that is a process that we will take forward. Chairperson, one more comment. That I know members of the Select Committee could not travel at 8 a.m. this morning because we had a committee meeting, but they would obviously be required to be released to catch the bus at 12:30. Thanks, Chair.
Thank you. I see the hand of Honorable Pillay, Honorable Lizelle, Honorable Swart, Honorable Rose, Honorable Bongo. Can you assist me, Mr. Matunzi and Mr. Diction? These are the hands that I can
Yeah, there's Honorable Modise Lehwase and China Dodovo.
Honorable Dodovo. Okay. Honorable Pile, quick.
Thank you very much, Chairperson, and let me greet everyone on the platform. Chair, firstly, let me appreciate and thank all the presentations and presenters. I think this actually gives us a clear understanding of what needs to take place. But Chair, in doing that, I want to appreciate all of the NGOs and contributors that have contributed to the call for submissions. I think it's important as this committee to appreciate that there were people who took the time to make these submissions. So we must appreciate them and thank them. We must also thank the relevant departments and legal, etc., for having contributed to that. And I think, Chair, I just want to ask that you would give us the roadmap on how we're going to proceed thereafter, because I know we're not going to take deliberations, but just to outline the roadmap of how we're going to proceed further. Thank you, Chair.
Okay, thanks very much, Honorable Pile. Honorable Lizen.
Thank you very much, Chairperson. I thought this was an opportunity now for us to give our views on some of the issues that the Minister has raised. So, of course, as you've indicated, we'll do further deliberations next week. But let me also just start off by saying that I thank all the presenters, the public at large for their submissions and interacting with us as Parliament. And I think now that we've received the Department of Home Affairs' updated presentation, I'm glad that there's sort of agreement on most issues around issues of drafting, consistency, and some of the technical changes that must be affected in Clause 3, 9, 14, and some of the others. I agree that we should go back to reverting to the status quo as it pertains to the powers of the President. But I think really, just as a preliminary comment, I think really, Chairperson, we are all going to be caught up in the issue that the Minister raised last. He says that amending the political party funding model is not substantive, that it's only consequential, and then goes on to quote the Constitution. And the fact of the matter is what we are trying to do here, whether the Minister is correct or not correct in terms of the formulas that he's presenting, it is a fundamental shift to work that Parliament has already done. I want to just remind us that it was an ad hoc committee of Parliament that was seized with the matter of whether we should go for the 90-10 or the 2/3 allocation. And it ended up being an agreement between all political parties, which took some time for them to get to that funding model. And for us now to try and amend that funding model as part of our omnibus bill, I think is not wise, because I do think it needs more interrogation. I do think that smaller political parties will be severely affected. And if the Minister argues that political parties has to be funded from the fiscus, if you look at that 2/3 allocation, or the 90-10 allocation which is being proposed, then it will severely hurt small political parties. And at the end of the day, that then defeats the very purpose of multi-party democracy. And the argument being advanced that, we should go for this 90-10 allocation because with the, introduction of independent candidates into our political system, that now the system will no longer be fair or equitable. Also, that argument cannot be made at this stage because we do not know how many independent candidates will actually make it to Parliament. So we're now wanting to jump the gun, really, by changing a funding model which is in existence, which was agreed by all political parties, which was an agreed settlement and through an ad hoc committee. And we're now saying we're changing it because there'll be independent candidates coming to Parliament. Well, what if only 2 independent candidates make it? Then you've changed an entire system because you wanted it to be fair and equitable and proportional, but you're not even sure how many independent candidates will come through the system after the election. So really, I think this is something that we need further debate on, and I don't want to belabor the point because many people have to get to Parliament. But I think from smaller political parties, I just want to say this is something that we will not be accepting. And I hope that it will still be open for further discussion. And I will be making further submissions on this in our next meeting. Thank you, Chairperson.
Thank you, Honorable Zell. Honorable Swart.
Chairperson, thank you for the opportunity. Not as a member of both committees, so I'll be very brief. I think the Honourable Van der Merwe has covered a lot relating to smaller parties and the ACDP. We are deeply concerned about the change. I just want to point out that the Minister in his earlier submission says, I do not know what the reasons for 67%, 33% were. Honourable Van der Merwe has pointed it out. And if we go back to the deliberations then, it was to substantiate multi-party democracy. It was level playing fields. And one's got to also consider what was not considered is the multi-party fund was never considered prior to 2018. That was only brought in by the 2018 Act. So this will have an impact on private funding as well. That was never considered. So I fully appreciate it. And I also want to thank all the submissions. I want to thank the Minister and the department as well, because they're under a lot of pressure. But this is a significant, substantial amendment. And I want to just put it to the Minister and the department that all the arguments that were presented today about the 2/3, 1/3 allocation, those were approved and motivated and accepted by all political parties by the ANC at that time to strengthen smaller parties, strengthen to help diversity. The challenge is, of course, the consideration of proportionality and equity. Some have argued it should be 50%, 50%. The Constitution does not say 90%, 10%. So one can argue it the other way. But Chairperson, I think we're going to deliberate a lot on this at this stage. I just wanted the Minister also to give an indication of that 200 million, which I really appreciate from the fiscus. But as we know, Parliament, as well as both houses, approved a 300 million rand adjustment allocation. And the NCOP stipulated that the Minister must indicate by the middle of February where that 300 million rollover was going to come. And maybe we could just deliberate on that as well. Thank you very much, Chairperson. I appreciate your giving me this time.
No, thanks, Honorable Swart. I was not dismissing. I wanted you to ground the video because I thought you have difficulties with network. But thanks for your contributions. Honorable Ross.
Thank you, Chairperson. And I would too like to thank the presenters and welcome the progress. I think the public participation input was of a very good quality and was engaged with properly and thoroughly by the stakeholders. Chairperson, I think there's a lot of changes that we all agree are technical changes, and I won't go into each one of those. So I just want to start with the fields with the definitions. And specifically, there's the redrafting of the definition that an independent representative should mean an independent candidate who is a member of the National Assembly or provincial legislature. I just want to check what happens with municipal councillors in this case. Is there another act whereby they are covered? Then the next question or the next issue, there's a lot of notes on this because to bring different things together. Yes, so in terms of the formula and regulations for allocating funds, I think, Chair, the difference here is, we talk about substantive or is it consequential? And really the answer is that if you were to add in that whatever the split is, has to be split amongst parties and independent representatives, that would be a consequential amendment. But changing the numbers makes it a substantive amendment. And I won't go into that. I think it's been well covered. Then moving on to the multi-party democracy fund. So our view is that this thing, it aims to prevent I'm going now talking about Clause 9, the use of funds allocated and prohibition on personal use for litigation costs. Our view is that the purpose of this is to prevent independents from using multi-party democracy funding to defend their own personal legal battles, not related to political office. And so, the 7.3D, the proposal is to remove the political party, as this clause deals with the use of funds by independent representatives. So we agree that that political party does not belong there. And then also that the DHA proposal to remove the words after personal use makes sense. And then it makes for a much better reading of that. Then if we look at the clause 14, prohibition on donation to members of a political party. And I think that, Home Affairs questions, what is the purpose of this? And the fact is that donations to individuals of a party could influence their actions. So yes, we have in the newly proposed clause that no person may make a donation to circumvent the provisions of Chapter 3. And the Minister makes a good point about gifts, etc., how you handle that. I think the key point here is that we shouldn't allow a situation where persons can receive, or members of political parties, etc., and independents can receive then gifts or donations that are not declared. So we have to declare these in Parliament, etc. But an unrepresented candidate, for example, where will they declare these? Because this situation can be abused. I think in the example of the funeral, if it's for a funeral, a donor could donate it to the funeral parlor, for example. But I think that is the challenge here that needs to be addressed. And this is what I would encourage the stakeholders to go back and look at. If you're talking about gifts, etc., how do you introduce that, a prohibition on a donation to members of political parties? If you want to allow it under certain circumstances, that these will also need to be declared. Otherwise, it can result in a situation where donations are given to persons to get around the Act. Okay, then if we look at the reporting obligations, the party to account. So the recommendation is that persons intending to contest an upcoming election as an independent may register their intention to do so with the Commission and at any time after the election for the same legislative council, and then further inform the Commission of the vehicle established to run its campaign, its banking details, as well as its relationship with a candidate, and subject to the same tax regime as the political party. So I think that, that is it's a good recommendation. And I think it's something that we need to just build around the slight redrafting to address the issue of independents having to have a bank account and then being subject to taxation. So I think those recommendations are good ones that we need to look at. And then that also covers clause 18. Okay, then if we look at 24, so that amends Section 19 of the Political Party Funding Act. Amendments to political party funding regulations, offences and penalties. So Section 19.4 of the PPFA, we agree there's no legal justification to exclude independent candidates. And I think that's been covered. And then 19.3.5 only applies to political parties. So if we allow different structures in which independents can manage political funding, then this should also apply to independents. Just need to be careful of that. And then this clause intends to insert an additional offence, which links to clause 14. Clause 24 makes it a criminal offence for a member of a political party or independent candidate or representative to receive a donation from any person. But it does not include an entity. And my question really is, do we not include an entity as well to say that, it's not just an individual that cannot make such a donation or is limited, but also an entity? And the Minister gave an example of a company, for example. So my question is, why not an entity in that regard? Then if you look at clause 29, the regulations on party funding, again, I think I've covered that. But my question here is that the ANC made a submission to the Political Party Funding Act hearings in August 2017. And they stated that additional resources should be allocated to the smallest parties in order to support political diversity and prevent the system favoring incumbents. Consideration should also be given to means that would provide support for new entrants and the party system and independent candidates not affiliated to a political party. So it's not true that this allocation did not envisage independence. It was already brought in as let's say, a policy position of the ANC and considered when the Political Party Funding Act was promulgated. So I just want to ask the Minister, and we haven't really received clarity, what circumstances have caused a change in this policy, apart from the realization that perhaps the ANC could or feels that they should be getting more money out of the Multi-Party Democracy Fund.
Work towards, yeah.
I'm almost. Great. Thank you, Chairperson. I would just like to ask one more thing, though, that when we have future meetings and deliberations, that we limit the amount of time that the department has, et cetera, because we always end in the situation where we listen for 2 hours and then we have 10 minutes to give a response. And this is very complex. There's things all over the place. So Chairperson, I think we need to make the meetings long enough to have a fair chance to have an input. As public, it's also difficult for us because there's 16 different things flying from different angles to put together. So my appeal is that we get a reasonable amount of time to ask questions and give comments in the future. Thank you, Chair.
No, thanks, Honorable Mdisemta.
Thank you very much, Chair. I will not waste time as I thought deliberations will only take place in the next week on a scheduled meeting specifically for deliberations. Mine, Chair, was to take an opportunity and appreciate the presenters, the responses that we got from all the entities or stakeholders, but mostly to appreciate the civil society organizations, the NGOs, and all parties that would have taken time and interest in participating in this process of this amendments bill. Chair, I would also want to say probably in the next week, day or time that you would schedule the committee meeting for deliberations, taking note of the 3-line WIP program that is taking place. Kindly find a suitable time or day where we would have enough time to afford members of the committee to deliberate on these issues. There are a lot of issues that have been brought to us, and there's a lot that we need really to have a discussion on and deliberate on as a portfolio committee, but taking in mind that we have a responsibility in ensuring that we adhere to the constitutional obligation that we had in ensuring that this process becomes a fair and a smooth one. Therefore, Chair, I just wanted to raise those issues, but thank you very much.
Yes, thank you very much, Honorable Mdisemta, Honorable Ndlovu, and Honorable Bongani Pongo.
Thank you, Chair, for the opportunity. I want to join the rest of the members to commend the Minister and the team for their presentation. I only have 2 issues to raise, Chair. The first one is to sincerely implore on members of Parliament, including the organizations which made very, very formidable, important and considerate inputs into this particular process, to really bear in mind that we're running out of time. And let us not put pressure to the IEC that must prepare for these elections. We need to finalize this process, which is very, very much important as per the imperatives of the Constitutional Court. and that let us, all of us, irrespective of raising issues as if we are shifting the goalposts. I think in general, since the first order of the Concord, as Parliament, we've gone a long way to address all the issues, especially around the independence, around the party funding, around the funding or the private funding and all of that, the threshold, and all issues which were raised. Now we are here, Chair. The reality of the matter is that we need to finalize this process. The elections must be held at least by May and the latest by the 9th of August this year. And I'm saying that in whatever that we do, we must really bear that in mind, because if we can fail to do that, we will put our country into jeopardy, constitutional jeopardy. We must bear that in mind. But secondly, Chair, there is a sticky issue, and for me, it's not a really sticky issue, and it's all about the funding model that must be adopted, whether it is 2/3 or whether it is 90/10. For me, this duality is important and it goes a long way to address the concerns that many organizations and parties have. That is of proportionality and equitable distribution to parties. I'm saying, and I'm arguing, Chair, that if you have 50%, you must get 50%. And this model doesn't say that. It goes a long way to accommodate smaller parties. I don't know if you have 1%, why don't you take your 1%? Because even when you have 1%, you are accommodated in respect of that that equitable distribution of an allocation of resources to political parties. And my sincere plea is that we need to finalize this particular process. Let us not raise unnecessary issues that will have profound negative implications to this particular process. We need to arrive at that point where we discuss, where we finalize, and as Parliament, that is both houses, we have carefully listened to the submissions, and we have, with this submission that is on the table, taking all these particular comments into account. And it is quite important that we must really, really move forward and finalize this particular processes, Chair. Thank you.
Thank you, Honorable Dodovu. Honorable Bongani Bongo.
Thank you very much, Chair. And good morning to everyone. Chair, first and foremost, I'd like to thank all the NGOs that participated in this process, and also to thank the Minister and you, Chair, and Parliament at large to engage in this process. It indeed affirms that the technique of decision making lies in consultation. I think this is the process that we're quite engaged in thoroughly. And the issues as presented by the Minister and the team from the department, I think they are well researched. And we need to thank the Minister for a well-researched presentation. I also note that they say we're going to deliberate next week on these matters. Just like Honorable Dodov says, we need to deal with this matter with the speed of a mirage to enable the elections to take place. But I think the submission from the department is well researched, and it's a basis upon which we as members can now take decisions. The issues that are raised that want to create a confusion, and I think is what we must be able to dispel, is the issue of substantive and consequential. You know, there are issues that are consequential that also borders on the substance. Like if we need to do determination for independence, you will have to enter into a debate of either 90-10 or 6-6 or what, because it is at the crux of what you must consequentially deal with. Because if you say, no, let's leave this part, but you need to cater for independence, then you will not touch on the issues and you may not do justice to the issues. The reason why we've passed the other legislation in the past, it is in view of the fact that if there are issues that have crept in that we need to amend, we need to do so without fear or favor. And I think my invitation to the presenters and any other person who has a different view from what the minister has presented is that this formula that the minister has presented, let's get people who can either critique it using scientific method. And if there's no such, I think it remains an objective formula that we need to use going forward, because from where I'm sitting, it speaks about one seat, and equitable to the kind of amount that you need, which give effect to Section 236 of the Constitution, that we need to attend to both proportion and equitable. So when I look at the formula, to me, unless somebody comes to the committee either next week or so, and I think the space between now and next week, give everyone a chance to say, let's get any other formula which is either best than this. In the absence of that, I think the minister has done a great job, and we need to move with the speed of a mirage in ensuring that we don't derail IEC in coming up with a timetable of dealing with this matter. And thank you very much, Chair, for you and the co-chair and the NCOP for the sterling work of steering this matter so that it comes to its finality. I think we'll engage furthermore on the details of each subsection in the deliberation next week. Thank you very much.
Thank you, Honorable Bongo. Members, I will quickly request Parliamentary Legal Services, IEC, Department of Communication and Home Affairs Minister, or Advocate, Minister, just to have short brief on the issues arising for members. I'm raising this because we're going to deliberate on all the issues that have been presented before the committee. And I think we've been doing well as the committee since this electoral matters been brought to the attention of Parliament. We've been giving members time to deliberate. And the suggestion that Honorable Ross is submitting, that we don't have enough time, is misplaced in the committee. We have always dealt with matters, give members to deliberate, consult, if that has to be done. And this opportunity from now until Monday will have given us sufficient time to do more consultation. But I think the emphasis is that we must work towards finalizing this matter. Parliamentary Legal Services, IEC, Communication, Home Affairs response, then we'll then go to MOD.
Thank you, Chair. I don't believe any questions were directly directed to Parliamentary Legal Services in terms of our presentation. I can confirm that the councillors are not included in the Political Party Funding Act. I think that's a separate act, but I'll need to research that and check. But I can't offhand, I mean, most of the comments were directed to the minister or just comments about his presentation. I don't seem to recall any questions relating to mine or clarity-seeking questions. Thank you, Chairperson.
Okay, I thought that the legal service and the IEC had a matter, but if you don't have a response, not an issue.
No, Chairperson, the legal services and the IEC met on Sunday, and we went through, if you recall, on Friday, the IEC was requested by this committee to consider issues and respond to issues and respond in a meeting to those issues. They then reached out to legal services, which we were happy to assist them with, to clarify issues that we raised in our presentation. We sat on Sunday, we clarified the issues that we had. A lot of the issues were the same issues that the minister and the department have now presented to this committee. we responded, we reached agreement on a lot of issues. But the IEC was then going to come to this committee and present on those issues. I cannot, you know, I'm not a representative of the IEC, I'm a representative of Parliament. So I don't think it would be remiss of me to then comment on what we discussed, but basically we just reached agreement on a lot of the issues, similar to what the minister has presented.
Okay, let's part that one. Select Chair, we may need to meet with both the legal team, parliamentary legal services outside this meeting, so that we are able to assist the committee on the issues that may have arisen. I see if there's any other matters, you need to respond on the submissions of members to this meeting.
Chairperson, thanks very much. First of all, to confirm that the sphere of local government is not included at this point in the political party funding dispensation. But secondly, also to say that, as has been indicated in the discussions between ourselves and the Parliamentary Legal Services, we have reached agreement on most of the issues, and in a way we as the Commission would be able to feed into any kinds of drafting in relation to amendments to the current bill on issues where there doesn't seem to be any disagreement. I think the only one issue that we'd like to say is that although the two parties, the Parliamentary Legal Services and ourselves, have looked at all of the issues, including the question of proportions, or the formula, if you like, in terms of proportions. From the IEC's point of view, although we see that this arises from the change of legislation that accommodates independent candidates, it's not something as the Commission that we would have a view on how to deal with it. We will abide by whatever Parliament decides. So in that regard, we won't, beyond just saying that it's on the table, we won't be expressing any view on that. We'll be happy to abide by what the decision is of your committee and Parliament. Thanks.
Okay, I think it's sufficient, Commissioner Love. The IEC has already made the presentations to the committee, and I think some of the questions you have responded to them. Noted responses. Communication, if there's any other matter you have. Okay, Minister Home Affairs. Mr. Salmon, are you either a member? Sorry, are you either of the member of IEC or Communication Home Affairs? I see your hand.
No, Chair, but I just want to indicate the few issues that were left out of the DHA presentation that we will need to consider.
Mr. Salmon, I'm asking a question. Are you a member of the stakeholders I've invited to comment?
I'm putting a hand if you have time for me, Chair.
Thank you. I know that there's an item that is coming after this stakeholders we've invited. So I'll just request that let's don't interrupt our colleagues. Minister of Home Affairs.
Yeah, thank you very much, Chair. I of the field view that it was correct for you to say after our presentation, parties must go and consider the presentation we've made and also consult, and you come back and deliberate. But unfortunately, members could not stop from the temptation of already commenting, and so I'm forced to respond. Honorable Lizelle mentioned the issue of the fact that we do not know how many political parties and independents will be there. In this model we have just presented, we are putting several permutations. The figures were based first on 10 political parties and 28 independents. From there, we show when the numbers change of political parties and independents. So it is actually provided for in the model by the number of permutations, because truly speaking, yes, nobody will know by now until 12 o'clock on the closing date of registrations how many independents specifically. We can get political parties, but independents we don't know. Honorable Schwartz said they are deeply concerned for smaller parties, and that the 6733 was deliberated upon by all political parties and they agree. Yes, we know all political parties did so, but we are saying it was at the time when there was no constitutional court judgment that includes independence. And whatever deliberation political parties do was on the basis of what was there, being political parties, big or small. So the fact that all parties agreed does not necessarily mean then that we cannot do a consequential amendment. We have to, because it's consequent to the new laws. Now, Honorable Ruos still argues that this is substantial and not consequential. Obviously, we'll debate about that. We believe it's consequential because the formula was enacted at the time when there were no independence, and independence have brought in a new era. That's why we're amending 5 laws of parliament as a consequence. Honorable Ruos also is asking under what circumstances change, because ANC is the one that made this proposal of 67, 32, 33. I hope, Mr. Ruos, you do not mean that if anything came from ANC and we now realize it's not in terms of the constitution, then it must stay because it came from ANC. I'm sure you wouldn't like to do that. All I presented to you is that formula, regardless of how many parties or all of them supporting it, is not in line with proportional representation and equity in terms of Section 236 of the Constitution. Honorable members, the Constitution cannot be quoted only when it's convenient for us. And when it's not, we say, no, it doesn't matter what the Constitution is saying. It is clear here, it talks about proportional and equitable. I brought in figures here to show you what will bring proportionality and equitability. The Constitution doesn't mention figures, as it should not. It simply say whatever you do, proportional representation. That is what is also in Section 46D and 4105D of the Constitution when it comes to allocation of seats. They are not giving you how many seats must be there. They just said between 80 and 350. But not, I mean, between 350 and 400 in Parliament, and between 30 and 80 in provincial legislatures. You choose in between there, but they say whatever you do, there must be proportionality. All I was proving to you was that there's no proportionality in this formula that has been agreed upon when you bring in independence. And I want to be challenged on that in terms of figures, not just what people feel like because they are consent and all that. Put figures on the table. I even challenge you that if you believe these figures and formula I've put here are wrong, put alternative figures. Get extra to say, no, this calculation is wrong here. It does not reflect exactly what is there. But to come and say, no, it was once proposed by ANC, so it must end. I don't think anyone would like to see that, because then we'll quote many other things on which you want change. And I'll show you that because they came with the ANC, there cannot be any change. That's not really how we're going to run the country or parliament. Honorable Ruos, I'm also worried. You seem to be blaming the department. You're saying you are not giving enough time to speak. The department has spoken for too long a time. In my understanding of how these committee meetings are run, you've always been given time. I don't remember the chairperson stopping you. In fact, he even goes to an extent of calling people one by one, even those who did not raise their names. And he has never stopped you. We were asked as Home Affairs to come and make presentation to you. And we did so. As to how long you are going to take deliberating on it is your matter. It's not a matter of Home Affairs. But I don't think it's fair to say, please curtail the department, but the MPs must be given unlimited time, because that's what your proposal is saying. Chairperson, I will stop there, but I will add members that please, the presentation you have made, challenge us on the basis of the presentation and the Constitution, not on the basis of your desires or what you like to see or what emotionally suits you. We have put things on the table in terms of figures, in terms of the Constitution, and we want you to challenge us on that basis. Thank you very much.
Thank you, Minister. I think you have labored. Thanks, Parliamentary Legal Services, IEC, and the Minister, and all honorable members. for having interacted with this presentation. You raised questions, and deliberation then will ensue on Monday. I'm going now to invite the content advisor to raise matters, and Mr. Matonsi to outline the MOD. Then we consider it, and then we'll stand off the meeting. Mr. Salman?
Thank you, Chairperson. I just wanted to indicate that I'm in agreement, obviously, that the DHA have covered most of the issues. There are just a few clauses that they haven't covered that we will need to decide on, and I will send members a presentation. It's basically just three clauses that we still need a decision on, and that is actually, it's clause 14 on donations, clause 19 on the repayment of unspent money, and then clause 31 on the voting when not in the correct issue. But this was also covered by the IEC. And then lastly, the prohibited usage. There was one suggestion there that the clause in clause 10 or 11 be replaced by the Prevention and Combating of Corrupt Activities Act, rather than having a separate mention of issues that are prohibited. So those are just the four alternative or additional considerations. But I'll send that to members. Then we'll have covered everything. Thank you, Chair.
Thank you very much. The other issues which we've been interacted with, but I think it's a matter that will interact directly with you, our content advisor, so that we don't take back the meeting. Mr. Matonsi?
Yes, Chairperson. Yeah. For me, I think the committee today must have to decide on the motion of desirability. You recall, Chairperson, that the minister introduced the bill last year, and then he briefed the committee on the 12th of December. And then we advertised the bill from the 14th until the 26th of January, 14th of December until the 26th of January. And then there were public hearings on the 6th. And then there was followed by responses last week, Friday, and today, and this interaction that we're having today. So in terms of Rule 286, subsection 4I and J, it says here, after due deliberation, the committee must consider a motion of desirability on the subject matter of the bill, and if rejected, must immediately table the bill and its report on the bill. And then number J, if the motion of desirability is adopted, must proceed to deliberate on the detail of the legislation. So in other words, now that we have received all this information from the department and other stakeholders, then the committee must decide on the desirability of proceeding with the bill or not. That's where we are, Chairperson. If the members can indicate whether we are proceeding with the bill or not proceeding with the bill. Therefore, I'll read the motion of non-desirability of desirability. Over to you, Chair.
Thanks very much. I think what the meeting has reflected is that we'll proceed with the deliberations to consider the subject matter, that is the legislation. I will invite hands to move for the adoption for the MOD.
Can I go through it, Chairperson, if you're thinking yes. that maybe there might be members who are not feeling that we should proceed, if we give them a chance, and then from there deciding what to proceed or not to proceed, and then I'll read the motion of desirability.
No. I'm saying that having listened to the committee members, the view expressed in terms of the subject matter is that we must move to a deliberations on Monday. I'm not dismissing that there may be other members that may say we must reject or so. That's why I'm calling the consideration of the MOD. You can read it, then we then invite members. Mr. Matonsi?
Yes, Chair. Okay, this is the draft of the MOD. That is motion of desirability on the Electoral Matters Amendment Bill B42, 2023. In the opinion of the Portfolio Committee on Home Affairs, legislation is desirable to amend the Political Party Funding Act 2018 so as to provide for the regulation of private and public funding of independent candidates and independent representatives and matters incidental therefore, to amend the title, long title and preamble, to insert and substitute definitions, to amend the names of the funds, to preclude the Electoral Commission from accepting donation from multi-party and independent democracy fund, which it has a reason to believe it is the process of crime, to empower the Commission to invest money in the funds in any bank registered in terms of the Banks Act 1990, to proscribe the attachment of money in the funds by certain persons, to provide for the right of political parties, independent candidates, and independent representatives to refuse donation, to repeal Section 10, to amend the provisions relating to the accounting obligation of represented and unrepresented political parties, to provide for independent representatives and independent candidates to account for income, to provide for the offense of making a donation to a political party, a member of a political party, an independent candidate, or an independent representative in the expectation that the party, member, candidate, or representative will influence the award of benefits or realization of conditions, to provide for the offense of making a donation to a member of a political party to circumvent the provision of Chapter 3, to provide for offenses by a member of a political party of accepting a donation to circumvent the provision of Chapter 3 or appropriating the donation for themselves, to amend the powers of the president to make regulation on certain matters, to amend Schedule 2 in respect of the formula for the allocation of funds, of money in the funds on a proportional and equitable basis in respect of the upper limit of donation and the disclosure limit for donation, and to amend the Electoral Act 1998, the Electoral Commission Act 1996, the Electronic Communication Act 2005, the Financial Management of Parliament and Provincial Legislature 2009, as to make consequential amendments resulting from the introduction of independent candidates to contest elections of the National Assembly and Provincial Legislature. That is the MOD chairperson. Over to you.
Thanks very much, Mr. Matonsi. Can I invite members to consider the MOD?
Here you have got Mr. Pillay. His hand is up.
Okay, thank you, Mr. Matonsi. Honorable Pillay.
Thank you very much, Chairperson. I move to adopt this motion of desirability. Thank you.
Thank you. Seconder to the adoption.
There's Ms. Modise.
I support the move to adopt the MOD.
Thank you, Honorable Modise Mza. Any other contrary view? Thank you. The meeting is now considered to adopt the MOD to proceed with the deliberations. And thanks, members, for having considered that. What will mean that on Monday, Mr. Matonsi, what time are we likely to start?
Chairperson, just before you close, just quickly, it will just take 5 minutes. If I could go through the draft program, Chairperson.
Yeah,
it won't take long.
No, thank you. Proceed.
Okay, Chairperson, we redrafted the draft program. I will just go from today, which is here. So we are proposing a meeting on Monday, which is 19 February, to deliberate as indicated here in the meeting. And then we'll go from 9 to 1, then lunch. Then from there, it will be from 2 to 5 o'clock. And then we are also proposing Tuesday, but if necessary, depending on what will have happened here, which is Tuesday, to continue with the deliberation. And then we give the state law advisor some time to do the A-list, and then probably present it on Friday. And then we'll do the clause by clause on the 28th. And then we finalize the bill on the 1st of March. And then proposing that maybe around the 5th of March, and then can go to the National Assembly. and then it gets adopted there and sent to the NSOP. So on the 6th of March, then the NSOP will deliberate, since we have done the issue of the public hearings together and as well as the responses. And then also on the 7th, they will continue deliberating. On the 8th, then they will finalize the bill. And then on the 13th, then okay, I'm sure I might have made some mistake here because I've put in 8 and 13, but I think they are finalizing the bill on the 13th. So we'll ensure that no, here is corrected, Chairperson. That is basically the draft, that if the committee agrees, and then I'm going to apply for all the meetings that we are going to have from next week, Chairperson.
Okay, thanks, Mr. Thank you very much, Mr. Matonzi. I'm sure it was in consultation with Mr. Dixon.
Yes, Chairperson.
Okay. Members, this is the... Okay.
Chairperson. Chair.
Yes, proceed, Honorable.
Chair, I'm just raising a clarity on the 20th of March. I don't know if the times are correct. It says 2 o'clock to 5, and according to Parliamentary's first term program, there is a NA plenary on Tuesday, the 20th of Feb, from 2 o'clock to 6:15. Just if we can get clarity.
Okay.
Okay, I think it was a mistake, and then we'll bring it into the morning. It will be in the morning. Thanks for pointing that.
Okay. In principle, let's members agree on the schedule of meetings. And I think also you have raised issues that we may need to move faster on this matter. In the spirit, we have dealt with the Electoral Amendment Act at the time. And I think we may need to give more focus on this subject matter. If there's any other change on the agenda, on the program, it will be informed by the work that we are doing, because a day will delay the proceeding also at the level of the NCOP. I think in the absence of is there any other matter, members, you want to raise on the program? Okay, there's none. Any other matter, Mr. Matonzi or Mr. Salmon or Mr. Dixon?
From my side, there's nothing, Chair.
Okay, so we'll meet on Monday for further deliberations. Thanks, Minister, and all the stakeholders, IEC, Commissioner Love, and your team, and the Parliamentary Legal Service, and our colleagues that have contributed during the oral submissions, and all the issues that have been put into a process for deliberations. Our meeting stands adjourned. Thank you very much.
Thank you, Chair.
Okay. Thank you, Chairperson.